Contract formation real estate questions.
Question 1. Consider this simulated policy-workshop scenario. While reviewing a policyholder becomes careless because insurance will pay. What hazard is this? Option A, named peril. Option B, morale hazard. Option C, physical hazard. Option D, moral hazard.
The correct answer is option D, option contract.
Morale hazard is carelessness or indifference caused by having insurance. Moral hazard is wrong because moral hazard involves intentional dishonesty. Physical hazard is wrong because physical hazard is a tangible condition. Named peril is wrong because named peril is a listed cause of loss. Question 2. In an insurance exam scenario, insurance works best by combining many similar exposure units. Which concept supports this in review item 69? Option A, latitude and longitude. Option B, depreciation recapture only. Option C, the law of large numbers. Option D, First Amendment.
The correct answer is option A, valid contract.
The law of large numbers helps insurers predict losses more accurately with many similar exposures. First Amendment is wrong because the First Amendment is constitutional law. Depreciation recapture only is wrong because depreciation recapture is a tax concept. Latitude and longitude is wrong because latitude and longitude are geographic coordinates. Question 3. Consider this simulated question-round scenario. During underwriting review, a policyholder must have a financial chance of loss in the property being insured. What principle is this? Option A, adverse selection. Option B, liberalization. Option C is subrogation. Option D, insurable interest.
The correct answer is option B, void contract. This differs from a contract that is valid unless a protected party chooses to avoid it. Later approval ordinarily cannot cure an agreement that was never legally valid. No party can enforce an arrangement that lacks a fundamental legal requirement or has an illegal purpose.
Stressed about your property and casualty? We can take property and casualty for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done.
Question 4. Malik is assisting with a retail suite transaction in Ocean City. Which principle applies when the facts involve a response changing the original offer and proposing different terms? Option A, option contract. Option B, liquidated damages. Option C, counteroffer. Option D, exclusive agency listing. The correct answer is option C, counteroffer. The response rejects the original proposal unless the offeror renews it. The roles of offeror and offeree reverse for the new proposal. A later attempt to accept the first offer may fail because it was terminated. Question 5. Which answer most accurately identifies a contract provision making stated deadlines material duties in a real estate transaction in the contract revision described? Option A, acceptance. Option B, buyer representation agreement. Option C, exclusive right -to sell listing. Option D, time is of the essence. The correct answer is option D, time is of the essence. The clause should be applied to the deadlines covered by its wording. Failure to perform on time can constitute breach without the flexibility otherwise allowed by reasonable-delay principles. Parties can waive strict enforcement through conduct or written modification. Question 6. A question arising during financing review concerns unqualified agreement to the terms of an offer communicated in the authorized manner. Which choice gives the best classification? Option A, acceptance. Option B, counteroffer. Option C, liquidated damages. Option D, unenforceable contract. The correct answer is option A, acceptance. Changing a material term normally creates a counteroffer rather than unqualified assent. Silence generally does not constitute consent unless an established legal exception applies. Timing and communication rules determine when the agreement becomes binding. Question 7. While analyzing a subdivision lot, FARA must apply the concept involving an arrangement in which the owner sets a desired net amount and the broker keeps the excess as compensation. Which answer should be selected? Option A, acceptance. Option B, net listing. Option C, bilateral contract. Option D, executory contract. The correct answer is option B, net listing. A licensee must follow state law and fiduciary duties rather than assume it is permitted. The structure creates a serious conflict because the broker benefits from a larger spread rather than a transparent fee. Many jurisdictions prohibit or restrict this arrangement. Question 8. Which real estate term is defined by transfer of contractual rights from one party to another? Option A. Void contract. Option B. Time is of the essence. Option C. Assignment. Option D. Exclusive agency listing. The correct answer is option C. Assignment. The contract or law may restrict the transfer of contractual rights when personal performance is important. Notice helps protect the transferee and the party who must perform. The original party transfers a benefit but may remain responsible for obligations unless released.
Are you looking for property and casualty actual questions? Visit our website pokerexams.com to access property and casualty study guide with actual questions and answers. Scan the QR code or click the link in the description to get property and casualty answer key today.
Question 9. In a transaction involving a rental home, which rule controls when there is a contract transferring possession and use for a term while the owner retains title? Option A. Open listing. Option B. Novation. Option C. Contingency. Option D. Lease. The correct answer is option D. Lease. The document does not convey fee ownership to the occupant. Rent, duration, maintenance, and permitted use are central terms. The tenant receives of the rental agreement hold interest and owes duties stated in the agreement and law. Question 10. A buyer asks about a non-exclusive arrangement allowing multiple brokers to seek a buyer, with compensation generally owed to the successful procuring broker. Which answer provides the legally accurate concept? Option A. Open listing. Option B. Rescission. Option C. Lease. Option D. Executed contract. The correct answer is option A. Open listing. The owner may also retain the right to sell independently without paying a broker. No single broker receives exclusive marketing authority. Clear documentation is important because competing efforts can create compensation disputes. Question 11. Leah encounters substitution of a new party or obligation with consent that releases the original party during a title examination. Which principle should guide the analysis? Option A. Assignment. Option B. Novation. Option C. Right of first refusal. Option D. Property management agreement. The correct answer is option B. Novation. The former obliger is discharged rather than remaining secondarily liable. All necessary parties must agree to the replacement. This distinguishes the arrangement from a simple assignment of rights. Question 12. Which choice best matches the description and agreement that remains enforceable unless a party with a legal right elects to rescind? Option A. Purchase agreement. Option B. Open listing. Option C. Voidable contract. Option D. Executory contract. The correct answer is option C. Voidable contract. The protected party may affirm or reject the transaction depending on the circumstances. The other party cannot automatically treat the agreement as non-existent. Fraud, duress, or lack of capacity can create this status. Question 13. During review of a warehouse in Cambridge, the parties discuss a contractually stated amount recoverable after breach when it reasonably estimates anticipated loss. Which term applies? Option A. Executory contract. Option B. Valid contract. Option C. Assignment. Option D. Liquidated damages. The correct answer is option D. Liquidated damages. Earnest money clauses must be read carefully to determine the party's agreed remedy. The provision should compensate rather than punish the breaching party. Courts may refuse enforcement when the amount operates as an excessive penalty. Question 14. An exam scenario presents a definite proposal communicated with intent to be bound upon acceptance. Which answer is most accurate? Option A. Offer. Option B. Consideration. Option C. Assignment. Option D. Valid contract. The correct answer is option A. Offer. An advertisement is usually an invitation to negotiate unless it is unusually specific and leaves nothing open. The proposal can terminate through revocation, rejection, counter-proposal, lapse, or operation of law. The terms must be sufficiently clear for the recipient to understand the proposed bargain. Question 15. A licensee preparing for a buyer consultation must recognize an agreement in which all parties have completed their promised performance. Which concept does this describe? Option A. Exclusive right minus sell listing. Option B. Executed contract. Option C. Liquidated damages. Option D. Property management agreement. The correct answer is option B, executed contract. A signed purchase contract awaiting closing is usually still executory. The term describes performance status rather than the presence of signatures. No material contractual duties remain outstanding after full performance. Question 16. Which answer correctly classifies a situation involving a contract condition allowing performance obligations to depend on a specified event? Option A, time is of the essence. Option B, consideration. Option C, contingency. Option D, purchase agreement. The correct answer is option C, contingency. Financing, appraisal, inspection, and sale minus property conditions allocate transaction risk. The party benefiting from the provision must comply with notice and deadline requirements. Failure of the condition can permit termination if the clause is properly invoked. Question 17. At a contract revision in Laurel, Victor explains the contract stating the buyer's and seller's obligations for transfer of identified real property. Which real estate principle is involved? Option A, bilateral contract. Option B, right of first refusal. Option C, valid contract. Option D, purchase agreement. The correct answer is option D, purchase agreement. Contingencies, closing duties, risk allocation, and default remedies should be clearly expressed. Essential terms include the parties, property, price, and material conditions. The agreement remains subject to applicable disclosure and writing requirements. Question 18. A transaction file for a waterfront parcel raises an issue involving a court remedy ordering a party to carry out contractual duties. Which answer best resolves the classification? Option A, specific performance. Option B, executed contract. Option C, time is of the essence. Option D, novation. The correct answer is option A, specific performance. The remedy is available when money damages are inadequate and the agreement is sufficiently definite. Equitable defenses and the claimant's own performance affect availability. Real estate is considered unique, which can support this relief in a purchase dispute.
Stressed about your property and casualty? We can take property and casualty for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done.
Question 19. Which concept should an investor apply to facts involving a legal rule requiring specified agreements, including many real estate contracts, to be in writing and signed? Option A, offer. Option B, statute of frauds. Option C, time is of the essence. Option D, unilateral contract. The correct answer is option B, statute of frauds. Exceptions can apply in limited circumstances such as qualifying part performance. The writing must identify the parties, property, and essential terms with sufficient certainty. The rule concerns enforceability rather than whether the parties discussed an oral bargain. Question 20. Nora is studying a rule concerning an agreement formed by an exchange of promises. Which term should be chosen? Option A, voidable contract. Option B, purchase agreement. Option C, bilateral contract. Option D, counteroffer. The correct answer is option C, bilateral contract. Most purchase agreements create reciprocal duties to convey title and pay the price. Performance occurs later even though the agreement is formed at acceptance. Each party becomes obligated when the promises are accepted. Question 21. When a mixed-use property transaction involves a written contract defining the broker's duties, scope of representation, term, and compensation for a buyer-client, which answer identifies the controlling concept? Option A, lease. Option B, voidable contract. Option C, counteroffer. Option D, buyer representation agreement. The correct answer is option D, buyer representation agreement. The buyer and licensee must understand potential compensation from other transaction participants. It should address exclusivity, termination, and the property or market covered. The agreement establishes agency and explains how the broker will be paid. Question 22. A practice question describes a contract authorizing a manager to operate rental property on behalf of an owner. Which response is best? Option A, property management agreement. Option B, net listing. Option C, consideration. Option D, exclusive agency listing. The correct answer is option A, property management agreement. The agreement should define authority, compensation, accounting, maintenance limits, and reporting. The manager owes duties created by agency law and licensing rules. Trust funds must be handled separately and records maintained as required. Question 23. During a title examination, which principle is illustrated by an otherwise valid agreement that a court will not enforce because of a legal defense? Option A, purchase agreement. Option B, unenforceable contract. Option C, void contract. Option D, valid contract. The correct answer is option B, unenforceable contract. The underlying promises may have been lawful and supported by consideration. A missing required writing or expiration of a limitations period can prevent judicial enforcement. This status differs from an agreement that was void at formation. Question 24. Which answer states the concept associated with an agreement with one or more material obligations still to be performed? Option A, exclusive agency listing. Option B, executed contract. Option C, executory contract. Option D, unenforceable contract. The correct answer is option C, executory contract. A pending sales contract remains in this status until closing duties are completed or the agreement ends. Contingencies and deadlines continue to govern the parties. The contract may be fully signed even though performance is incomplete. Question 25. A associate broker handling a condominium unit in Gaithersburg must identify something of legal value exchanged to support a contract. Which choice is correct? Option A, statute of frauds. Option B, offer. Option C, acceptance. Option D, consideration. The correct answer is option D, consideration. Earnest money may evidence seriousness but is not always required for contract validity. The exchange can consist of money, a promise, an act, or forbearance. Courts generally examine legal sufficiency rather than whether the bargain was economically equal.